All right, welcome everybody to our meeting of the State Bar of California's Provisional Licensure Working Group. This meeting is being recorded. Wanted to let folks know the topic that is for discussion is expansion of the Provisional Licensure Program, and in particular to pick up where we left off last time, which is to discuss whether there could be a pathway to admission to the state bar, and if so, what requirements to put around it, including things like hours of supervision and other such requirements. That is the topic for discussion. I would like to ask Donna to give an update on the rollout of the Provisional Licensure Program. We gave an update to the full board yesterday, but we'll give all of you a brief update and then open it up for public comment.
Yes, I am happy to report, and the numbers are bigger than they were yesterday. As of last night, we had over 550 applicants for the program. We have approved 122 as of last night. 122 of the applicants who had submitted fully completed applications. We approved 33 on the very first day, as a matter of fact. We also have on our website a beautiful way to look up provisionally licensed lawyers. You can check out the provisionally licensed lawyers and their supervisors. Going through the admissions webpage, looking at the search for provisionally licensed lawyers. And Amy and Audrey and I were actually just on, and Caroline, who's on the call with us today too, we're just participating in a webinar with CLA that CLA arranged and hosted to encourage lawyers to take on provisionally licensed lawyers under the program. We had an hour. The entire CLA leadership, including CYLA leadership, participated in that webinar. There were about at its height, I think there were about 45 or 50 attendees who were participating on the call. I think a lot of them were wanting to become provisionally licensed lawyers, but I hope that some were and were also potential employers. I am also happy to report that CLA has extended free membership to provisionally licensed lawyers and created a community forum for provisional licensure on their website. So individuals who would like to be provisionally licensed and individuals who are interested in hiring provisionally licensed lawyers can meet up in that forum. I also encouraged on that webinar, to the extent anybody who was listening is affiliated with any of the local, regional, or affinity bar associations, to do similar things for their members. We will be reaching out to the affinity bars, especially to officially ask them to do the same, or something similar, something creative or similar to what CLA is doing. So it's really excited to see the participation from the California Lawyers Association and what they were striving to do to make this to help potential provisionally licensed lawyers find some real opportunities to get work. Interestingly, the CLA leadership person who was on the webinar, she has a family, she works at a family law firm. They have hired 2 individuals who are applying for provisional licensure. One of them applied the first day and was approved already, and she was talking about the huge benefit of having a provisionally licensed lawyer and somebody who is new and eager and participating with them, and that the individual is already doing motions and really doing clear legal work and really trying to encourage others to follow suit.
Great, thank you, Donna. And really a huge thank you to all of the State Bar staff and leadership for standing up this program so quickly in just a matter of days. you know, and it was only back in, I can't even remember, July or August, when the Supreme Court asked us to consider this program. So it's really extraordinary work, and really heartened to see the effect it's already have on providing a pathway to working as attorneys for the 2020 graduates. So thank you. I realized I forgot to have roll call. So if we could pause and ask Ezra to call roll, please.
Eileen Chin,
Here.
Ruben Duran,
Here.
Rob Barrett,
Here.
Rupa Bandari,
Here.
Diane Boyer-Vine,
Here.
Julie Crisp,
Here.
Terry Garland, Dolores Heisinger,
Here.
Jennifer Bacon-Henning,
Here.
Judge James Herman, Paul Kramer,
Here.
Carol Langford, Laraz Moody Villarose,
Here.
Cindy Panuco,
Here.
Vern Pearson, Judge Jesus Rodriguez, Angela Sierra, Philip Talbert,
Here.
Tiffany Townend Blacknell, Neil Gupta,
Here.
and Greg Fortescue.
Here.
Thank you.
All right. Well, we have more than a quorum. Welcome, everyone. And thank you, Donna, for that update on the up and running provisional licensure program. So now I'd like to open it up for public comment. I want to make sure folks know we have received all the written comments that have been received. Those have been distributed to the working group members, and we appreciate everybody who's taken the time to weigh in and provided really thoughtful ideas on how we can move forward. Those of you in the audience, there's 133 of you and growing as we speak. If you'd like to make public comment, please go ahead and use the raise hand function and we will take you in order. And I would ask Donna to please run it since you've done it so well in the past.
You give me a compliment and then I don't unmute myself. Okay, so turning to the first person with their hand raised, Devin, if you will give Helen Ho the mic. Helen, you will have 2 minutes.
Yes, good afternoon. Can you hear me?
I can.
Yes.
Thank you very much.
Thank you. Yeah, good afternoon, members of the working group. My name is Helen Ho, and I took the 2020 February bar and scored above a 1390 on the first read. So I thank you for holding this meeting. As you are deciding on the expansion of the provisional licensure program, I respectfully recommend that you please include previous California bar exam takers who scored 1390 or higher on their first read, because they also have already demonstrated that they meet the standard of minimum competence to practice law. The score of 1390 or higher that an applicant needs to pass the first read is no different from the new cut score of 1390. Please do not forget these individuals, because they too scored a 1390 or higher, and it would be arbitrary to deny them of the PLP with a pathway to licensure. On behalf of the past bar applicants who will be affected by today's decision, I respectfully recommend that members of the working group to adopt the expansion of the PLP and to include individuals who scored a 1390 or higher on their first read. I thank you for your time and consideration. Thank you.
So Donna, should we just give a little clarity as to what's been already decided in previous meetings and what will be decided today?
Yes.
I just want to make sure that folks keep their comments on point to the decision that's been made today. So our previous provisional licensure working group has decided on recommending to the Supreme Court for their consideration a proposal that the provisional licensure program be expanded to include individuals who sat for the California bar exam in July 2015 or later who scored 1390 or higher. So that's been discussed and decided by this working group already. So for folks who are waiting to comment to persuade us to do so, we decided that last time, and that will be presented to the Supreme Court. And so what is before us today as a working group is a decision as to what conditions to impose on a potential pathway to full licensure upon completion of the provisional licensure program.
Okay. Turning to the next public commenter, Gabriel Buelna.
Yes, can you hear me?
I can. Thank you. You have 2 minutes.
Thank you. Again, my name is Gabriel Buelna. I'm zooming in from Los Angeles. I took the bar in February of 2020 and received over 1390. I want to thank you for taking the time to come up with several options for those that received over 1390 for the past 5 years. And I specifically support proposed rule 9.49.1. Your thoughtfulness is very appreciated. Because of the pandemic, many businesses are shutting down and families are losing jobs and the ability to house and feed our families. This is why I would respectfully request that the State Bar and California Supreme Court consider administrative processes that would allow for this process with affected cohort to be expedited in order for us to be employed as soon as possible. We understand health and safety, and many of us are already in the system. It would benefit tens of thousands of Californians to have the process finalized and this cohort working by the second week of December if possible. Between spouses, significant others, children, and dependents, thousands of Californians need the process to be expedited. Thank you very much for your time.
Thank you, Mr. Buelna. Turning next to Alicia.
Hi, good afternoon. I'm an attorney in another jurisdiction calling in for my full support. Thank you all for taking the time today to expand upon the understanding of the provisional licensure program with the pathway to licensure by considering the hours and supervisory requirements for this program. So those that have scored a 1390 or above in the past 5 years have already met the minimum competency requirement by today's standards. Therefore, a minimum number of supervised hours should really be required, especially for the most recent examinees. Many of these examinees have also been working in the past few months by taking on either volunteer legal positions, supervised pro bono, and paid attorney positions in other jurisdictions. So the working group may want to consider allowing these hours to be included for the program's purposes so that these individuals can begin practicing in California as soon as possible. So thank you all again for your consideration and really appreciate the hard work and great effort this group has made so far. Thank you.
Thank you. Turning next to Bijan Calderon.
Yes, hello. My name is Bijan Moseni Calderon. I am calling to speak in support of the expansion of the Provisional Licensure Program with a pathway to licensure. I'd like to first begin by commending the working group for addressing this matter of equity. I think it's a step in the right direction and an important avenue for individuals who have otherwise met every requirement for licensure, so thank you. I've read through the proposed draft and it looks great. And so moving to the purpose of this meeting, to determine the number of hours required, I'd like to advocate for at most 360 hours to be required. Recognizing that this licensure program is an additional requirement, not required of any other attorney, I think it's important to strike a balance that allows people who have met every other requirement to join that profession. And I think that a requirement of at most 360 hours is a good number. 360 hours is the average length of an externship that most people who are applying to be attorneys within the State Bar have already gone through. And it'll be sufficient to determine competency of applicants who have achieved a passing score under the current standard. With this in mind, I ask that the working group adopt this rule, and thank you.
Thank you. Moving on to our next public commenter, E. Roth.
Hi, can you hear me?
We can. Thank you. You'll have 2 minutes.
Okay. Thank you all so much for joining today. And I want to begin by thanking you all for working so diligently to putting this program together. Your compassion does not go unnoticed. I want to mention something that I think is essential going forward, especially in an expansion of the program. I believe this might be an unintentional oversight, but currently the program seems to exclude those who wish to work in the public sector, specifically for the federal government. And this is because many of our supervisors may not be barred in California due to being able to practice in a federal jurisdiction if they're barred anywhere. And the reason why I say it's an unintentional exclusion is because different field offices have different hierarchies, and the supervisors in these different field offices may or may not have been barred in California or elsewhere. And so in my situation, my supervisor is, even though having practiced in California for over 20 years, but is barred in a different state, would not qualify as a supervisor for me per se. But if I were to work in a field office 20 miles away, I know that supervisor is a California licensed attorney. And so it's just this unintentional exclusion that would impact students like me and those going forward who do wish to qualify for this program and who have been gravely impacted by the pandemic that will be excluded. So I just hope this committee can keep that in mind. Thank you.
Thank you. Our next, excuse me, our next public commenter, Hani Habas.
Good afternoon. Can you hear me?
We can, thank you. You have 2 minutes.
All right. Thank you so much all for your time. And also thank you for everything that you've been through. I honestly would never want to switch places with you. I would never want to be in your position. And you guys are very tough for that. So kudos and bravo and brava. With that being said, one thing that hasn't been mentioned, the provisional licensure program that I'm curious about is with respect to fee splitting or payments. The way I look at it and the way that I see it is we're pretty much able to do anything and everything under the sun under a supervised lawyer or an attorney. The reason why this might become like a good thing for people like us, especially experiencing the pandemic, is you know we're going through having to pay our loans, and we're also people that could be bringing in a lot of clients. I know this sounds crazy off the cuff, but I think it's just something that should be addressed, whether, you know, however you guys decide which way to go about it. But I think that it would be a benefit to help pay off loans. It help us to also compensate us for the work that we are doing. Because if we're writing, drafting motions, showing up in court, showing up to depositions, negotiating with adjusters, we're doing everything. There's nothing that we're not really doing. And it's just oversight by an attorney. But that's all I had to really say on that. And thank you very much. And I hope my question isn't insane, but you know, I just did not see it anywhere on the provisional licensure program. And, you know, I want to follow the rules to the T on this. Thank you.
Thank you. Our next speaker is Kathleen Beckett.
Good afternoon, committee. Thank you so much for your time. I want to thank you for reviewing the submitted comments and the proposed rule 9.491. I know this task has been more onerous than you anticipated, and we really do appreciate all. Thank you so much. Second, I wanted to remind you that the pathway program being discussed was previously and publicly agendized as being with a pathway to licensure. And so all endorsements previously received did in fact endorse the pathway and remain relevant and should be duly considered today. Third, I ask that having already met or exceeded the current competency standard, only a minimum number of supervised hours be required, especially as applied to most recent examinees, many of whom already have been subject to post-bar supervision through clerkships or volunteer work. And finally, I ask that to the extent possible, and I do know there are limitations, the approval process be expedited, as many of us do have immediate employment or pro bono opportunities that hinge on our licensure. And as COVID continues to ravage our communities, our ability to work is needed now more than ever. I thank you for your compassion and consideration and wish you all safe and healthy holidays.
Thank you, Ms. Beckett. Our next speaker, Mr. Evan Miller.
Hi, can you hear me?
We can, thank you. You have 2 minutes.
All right, thank you. My name is Evan Miller. I'm a graduate of Santa Clara Law, and I also want to announce my support for the proposed rule 9.49.1. Specifically, you'll all notice, as you've seen the plan, that there's different hour schemes. And I want to really push for number 4, where it starts at 240 hours, which is connected to the big Ohio State working paper that came out earlier this year. I think this plan, where it starts at 240 and then increases by 2 40-hour working weeks going back for each exam, it really has the most credibility. This paper was authored by the foremost experts on law licensing in this country, including Professor Deborah Merritt, who recently, as many of you know, authored a groundbreaking law licensing study recently. And I really think that plan, particularly if you decide to adopt a waiver, is really the most ideal one. And then I also just kind of want to reiterate that, as you have this entire discussion, to remember that all of these, everyone who would be under this plan and who this would apply to are people who've already demonstrated their competence to practice. So there's really not much to worry about. So, whether or not to adopt a waiver, the waiver, there's no threat to the public. So I think it's just important to remember that at all points in time, even when comparing a possible waiver to other programs throughout the country, those are the programs for people who hadn't taken a bar yet, whereas this group of people has already taken an exam and demonstrated competence. And it's also important to remember that, the lion's share of people who are would have this applied to them, people who scored 1390 or higher on the February 2020 exam or the July 2019 exam. That's really the largest group of people. So it's not really, there's very few people who have had this applied to them in going back, more 3 or 4 or 5 years. And thank you all for taking this under consideration. And I really hope you all adopt the waiver. Thank you.
Thank you, Mr. Miller. Our next speaker, Jasmine Martin. Ms. Martin, you have the mic.
Hello.
We can hear you now. You have 2 minutes.
Thank you. Thank you for holding this meeting and considering expanding the provisional licensing program to 1390 applicants. And I thank you for expanding it to the applicants as far back as 2015. I wanted to reassure the working group that addressing these hours is in fact within the scope of the purpose of the PLL program, as COVID-19 has not only affected the passing rate of February 2020 exam takers, but has revealed the seriousness of the inequitable impact of the previous cut score. I want to also caution the working group to keep in mind the risk of inadvertent hazing by an arbitrary hourly requirement, and the risk of employers increasing the minimum qualifications, as I've seen in recent job postings asking for unencumbered attorneys to apply to their jobs. If you can maintain a standard that will not be too burdensome on supervising attorneys and can reduce the risk of any long-term encumbrance, that will be greatly appreciated. Again, I thank you for your time and wish you a safe and happy holiday.
Thank you. Our next speaker is, I apologize, I'm just going to use the first name, Sanaz.
Good afternoon. I just wanted to reiterate that I took the February 2020 bar exam. I scored above 1390, and as a repeat bar taker, I've been forced to take another job to pay for bills and to bring income into my home. So I would really ask the working group to take that into consideration when they're going to adopt the required supervised hours for legal work, as well as to take into consideration that we are definitely in a pandemic, and with the court system, everything is being transferred remotely. So counsel are being asked to appear via WebEx or court call to make court appearances. A lot of attorneys are not in court, so a lot of the public agencies are not really able to provide that necessary legal work to supervise attorneys in court, because there is that need of limiting court appearances. So I would hope that one of the concerns of the working group last meeting was the recent competency of these individuals that are going to be going into the workplace. So I would ask that someone who took the exam in February 2020, who has a positive moral character application on file and who has taken the NPRE should be given some leeway and kind of make the playing field fair for them to be able to be granted full licensure with an exam waiver. Again, thank you so much.
Thank you. Our next commenter, Ileana Silver.
Am I being heard?
Yes, you are. You have 2 minutes.
Yes. Hi. So I just want to thank everybody as well regarding, taking the time and consideration as to what's been going on. However, just to re-emphasize what a few other people had mentioned is that, this pathway to full licensure would be helpful for repeat takers. I took the bar in February 2020 and I scored above a 1390. I have a satisfactory moral character and fitness, and as well as a passing NPRE score. The unfortunate situation about what's currently happening is that we are in a pandemic. However, this has been a systematic issue since long before that. This issue of lowering the pass rate was also raised in 2017 and attempted to apply retroactively. Had that issue been resolved then, the current situation we're in now as well with lowering the score, I would have been licensed in 2017 because I did score above a 1390. I've been taking the bar and trying as much as I can. I've scored above the 1390 on multiple occasions, and I feel that I have myself and people and others in my same situation have also been able to prove themselves beyond their minimum competency of being able to practice. I've been working in law firms since I graduated law school. I perform legal tasks as an attorney would in regards to drafting memos, writing complaints, preparing documents to be filed with the court. And I believe that this pathway to a full licensure will be an assistance to everybody that has systematically continued to fail the bar exam. And also think about just the consequences that have come with that. Personally speaking, I've never had any issues with anxiety or depression, but because of the pressure and the repeat taking and that situation of not being able to pass the bar, and the way that it impacts my family, my student loans.
Ms. Silver, I'm sorry, your time is up.
Thank you.
Thank you. Our next speaker is Eliza Yasinska.
Good afternoon.
Good afternoon. You have 2 minutes.
Awesome. I secondhand the 360 hours that's been proposed by the working group. I believe that's very reasonable, but I do ask for the flexibility in the time required for those hours to be completed. As you know, we're all in the holiday season. Offices are closed due to the pandemic. Children are at school. There are scheduled vacations, seasonal contracts. I am actually working in a non-legal position and do have contracts like many other people to be able to pay the bills. So for financial reasons, I would ask that the group would consider not putting a time limit on completing those hours within 6 or 8 weeks, because some of us are very anxious, of course, to enter the program, but they're not might be able to enter it right away, or might be able to do 5 or 10 hours at a time a week in order to sustain ourselves financially. So I'm proposing that the group will consider having 6 to 12 months time limit ending in December of 2021 to complete any amount of hours that the group would decide that is appropriate. But I do ask that you would implement the program right away so we can start planning and we can move forward and be fully licensed. Thank you.
Thank you for your comment. Shireen Gabriel.
Okay, I think we're good. Thank you very much for everything that you've all done and for calling on me. I do appreciate that everyone is considering this after having done it the same way for so many years. I am a repeater who is also a 1390 from February, and I've been working closely with an established attorney for almost 6 years, including being second chair in long cause criminal trials in several of them. So I know that I'm ready to go, and I know that several of my peers are in a similar position. So what I'm asking of today is that we can, as 1390ers, get some assurance that we will not have to take that test again, so that we can just continue moving forward and allowing ourselves to immerse with the attorneys who have been willing to take us on in the interim, that we do get that exam waiver. I also am hoping that they will address the little rebels like myself who have not yet completed moral character, that, you know, that would just be part of the conditions to be admitted provisionally, but that it not being done would not prevent it or anything like that. Also wondering if they will acknowledge any past work that any of us have done while working closely with an attorney, maybe if it's an attorney who will continue to supervise us and mentor us. And of course, when could we expect that this conversation, that this submission would be made to the state bar? So thank you, or excuse me, to the court. So thank you again. I know that none of you had to do this, but you are, and I'm just hoping that I can get some answers on timeframes and how this would apply to the individually nuanced situations. Thank you so much.
Thank you. Madam Chair, I'm recommending maybe just a couple more public comments, maybe take us to about 2:40 so that we have sufficient time for the working group to thoughtfully consider the remaining item.
That makes sense. Thanks, Donna.
Okay, so next we have Libby.
Hi, good afternoon, everyone. Hope everyone's staying. Thanks. Hope everyone's staying safe. I wanted to propose that those who scored above a 1390, at least in February 2020, but in the interest of equity in the past 5 years, be granted an exam waiver and no additional hour requirements or no hour requirements. And I say that because, as someone said earlier, the bar cut score in this conversation around changing it actually stemmed from 2017, and the state bar and the Supreme Court failed to do what was right when they found the research that found that that 1440 cut score was actually arbitrary. And I also encourage those on the board right now, on the provisional working group, to YouTube a video lecture series by Professor Victor D. Quintanilla from Indiana School of Law. And in that video lecture series, him, Professors Devin Carbato and Cheryl Harris from UCLA actually deconstructed what the choice of the 1440 bar exam in California meant. And they found that it meant that it was a choice about the legal profession's racial and ethnic makeup. And they found that that the California cut score 1440 produced stark racial and ethnic disparities, whereas 80.5% of white applicants eventually passed the bar exam during the period in which 1440 was a cut score. Just 53.1% of Black applicants did. A lower cut score would have substantially reduced the racial and ethnic disparities of the bar exam. So in all, what I'm asking is for the Provisional Licensing Working Group to essentially do what the State Bar and the Supreme Court of California should have done at least 3 years ago. And in the interest of justice, ensure that those who have already shown their competency by scoring above 1390 be granted full licensure without an exam requirement and without our requirements. Thank you.
Thank you. Our final commenter, Betsy Crowder.
Hi, thank you. Can you hear me?
Yes, thank you, Ms. Crowder.
Thank you so much. I just want to start off thanking everyone in the working group for taking this on and reiterate, I know that you don't have to do this and you haven't done this before and it's a big feat. So I speak for everyone I know who's in my position and we're all very appreciative. I just want to say a couple things that I don't think have been mentioned because I support everything that's already been said, but there's no need to rehash. First of all, what kind of work will be required under this provisional licensing program in order to get licensed? Do you have to work in a provisional licensed attorney role, or can you work as a law clerk or a postbar clerk? Because I know, as someone mentioned earlier, that there are people who are not taking this provisional licensing attorney program very seriously. They are stating in their job ads that provisional licensing attorneys will be paid $35,000. In a city like San Diego, where I live, that's what paralegals would be paid, or legal secretaries, not a full-blown attorney. And there are ads stating that they won't hire people who are provisionally licensed. So I'd also urge more communication from the State Bar, if this program is expanded to include us, that someone who's a provisionally licensed attorney would be should be treated as an attorney. I'd also just ask the working group to consider, what does supervised mean? And I'm running out of time, and I would urge the committee to approve the lowest number of hours and hours that have already been worked since the candidates have received their 1390 score. Thank you.
Thank you, Ms. Crowder. With that, I would just note that we have 4 additional, every moment there's somebody else adds their hand. So we have 6 additional hands raised that we will not be able to get to during this public comment period. Thank you to everybody who has provided comment to the working group. And as discussed a few minutes ago, I think we need to make sure to leave sufficient time to thoughtfully discuss the remaining issues. So Madam Chair, I turn it over to you.
Great, thank you, Donna. So you'll see in the materials that have been posted and that were circulated a chart that shows the various other jurisdictions that do grant admission without a bar exam. These were changes made in 2020. Some of them, some have different requirements as to how much supervision is needed, how many hours are required, and the like. You'll see after that a proposed rule. And thank you, Donna, to you and your team for drafting this. Much of this has been discussed already by this provisional licensure working group. I think the items that have not yet been discussed are the ones that appear at the end of page 2. I don't think we discussed the termination provision, Donna, but I do think that is a good idea. Am I correct? We hadn't discussed that before?
We have not discussed that before.
Okay. And then the other item, which is really the meatiest topic for discussion and that most public comment has been addressed to, is this pathway to admission to the State Bar, which appears in provision F with a number of options. So why don't we first take up F, since that's going to require the most discussion. You can see there's a number of options that do appear. Starting on page 3, they start with the most number of hours and proceed to the lowest number of hours. And then there's a sort of abbreviated option that perhaps may be less administratively burdensome. And wanted to open it up for discussion. Unless, Donna, you wanted to provide some more color around how these 4 options developed.
Yes, thank you. So just actually, in response to one of the public comments that was received, the parentheticals that are describing, for example, 240 hours, it says, yeah, it's 6 40-hour work weeks. That was just for the committee to be able to wrap their arms around what 240 hours meant. It was not drafted in a way to suggest that those 240 hours needed to be completed in that period of time. Obviously, that is, if the working group wants to put a time provision on which the hours need to be completed, that's something that the group can consider. That's not what was intended with this draft. It really was just to help all of us contextualize what 240 hours or 320 or 360 hours meant. And in large part, the totals were the starting points were selected looking at what the requirement is in Utah, what the recommendation was in the Ohio State University Law School paper that one of our public commenters, Mr. Miller, referenced. And then sort of really increments in between that, sort of between that 240, 360 hours, getting a sense. Someone had mentioned at one point that in one of our earlier working group meetings that it should be no more than the number of hours or the amount of time it would take for grading of the bar exam. And just for context, we project typically for an exam the size that the October one was 16 weeks for grading that exam. So none of these, all of these proposals as a starting point start less than that 16 weeks. But obviously they go up after what shows here, sort of based on some of the public suggestions we had received, an incremental increase based on how recently you scored at that 1390 or higher level. And then as Hyland mentioned, the last option collapses some of that. So there isn't sort of an additional 2 weeks or 4 weeks of supervised legal practice that's needed for each exam as we go back in time, but rather lumping some exams together. So you're just looking at a couple of options, 240 hours if it was between July 2017 exam and the most recent exam, or 360 hours if it was prior to the July 2017 exam. Just again, as sort of different ways to visualize what this could look like for the working group's consideration.
And then also to piggyback on that, given the questions posed in public comment, the legal work that is contemplated would be the legal work that's done under the supervision that's required in the provisional licensure program. And so Donna, given that there's no time limit on it, I assume that because the program is set to, end or at least be up for reconsideration for ending in 2022, it would be completion of these hours at any point during that time period?
Yes, as drafted, that's the way I would perceive it as well. As long as those hours are completed before the program ceases, then that would be permissible.
Okay. All right, so anyone, questions, comments from the working group? Feel free to either raise your hand or use the raise hand feature, which appears if you click on participants at the bottom of your screen, I think. If you're on the panelists tab, yep. Go ahead, Diane.
Thank you. So I wasn't at the last call. You guys did all the hard work then. Sorry about that. So I'm catching up. So two things. Why this differentiation of hours from a 2017 graduate versus a 2020? And then I think somebody asked in the public period, is any of this retroactive, or does for example, the 2015 graduate have to get 960 hours starting from the time? I assume it starts from that time because it has to be part of the provisional licensing program. So I'm trying to figure out why we have this big differential. And then I think I answered my own question, the last one. Just if you could confirm that.
Yeah, so I think you're right. Yes, it would be when as part of the program. So when the program starts. To go to your first question, there was some discussion last time. A number of working group members expressed a concern that for folks who took the bar exam many years ago, say in 2015, that the topics that they learned while they were studying for the bar exam may not be as fresh in their mind as somebody who sat for a more recent exam. And so there was an expression of a desire by some members of the working group to impose some more hours requirements to make sure that those folks had the knowledge that one would have if you had taken the exam more recently.
But we're not requiring them to take the exam again, right? This is the path toward licensure.
Yes.
Thank you.
Yep. Neil, you have your hand raised.
Yeah, you just answered. I was going to answer the question
Oh.
But you did it perfectly. So Amy, I just want to sort of repeat the fact that this is part of the reason why the court kind of struggled on the issue of retroactivity, because it realized, oh, okay, if somebody's coming in with a score from July 2015 of 1390, and you compare that to a person that is coming in with a score of 1390 from February 2020, we don't know what the person from 2015 has done in terms of keeping up with California law. And sort of along the same lines too, you know, on the draft in F, the phraseology of hours of legal work, what I recommend is to change that to hours of legal practice. Why? Because we're trying to make clear that these folks are able to fully practice law. And this is about the practice of law. This is not about being, say, a paralegal or doing the kind of limited post-bar work that folks do. These are folks able to do full law practice.
Are we saying full law practice while, oh, I'm sorry, I should have raised my hands.
Go ahead, Cindy.
Just to clarify, Neil, you're saying full law practice after being provisionally licensed so that they will have engaged in actual,
Right.
you know, potential signed pleading, like where they were where they had to have carefully read, you know, the case law and signed as an officer of the court, some pleadings and documents appeared in court. Yeah, okay.
So Paul, you have your hand raised. Go ahead.
Yeah, I'm still struggling with the whole thing, but on a technical basis, Donna, how is this going to interact with the 5-year rule that requires that after you do pass the bar, you have to complete all the other requirements and be sworn in within 5 years? Somebody in 2015, especially with the longer hours requirement, is not going to be able to achieve that. Do we have to do some drafting to make that possible if we decide to let it go forward that way?
So I don't think so, because they didn't pass the bar in 2015, right? We are saying that they will be admitted. Well, let me, as I'm talking out loud, let me sort of pose this question back to Caroline or Amy or Audrey. Does the rule say that the score that they got is valid, or does it say that if it only applies if they passed in 5 years ago?
Yes. Mm-hmm. It's the score is used for the eligibility criteria.
So in this instance, we're effectively changing that by this rule by saying, if you got a score of 1390 in July 2015, then you can be admitted using that score, assuming you had the moral character and PRE, et cetera.
Exactly. Mm-hmm.
Okay, but then would there be no practical limit as to when they could complete the requirements if they complete the provisional licensing step? They could wait theoretically 10 years or more to finish the rest?
I thought I put something in on that, and it was.
Oh, I see your point. Yeah. I think it's at the end. If you look after the options that are presented, you'll see in sub 4, so subdivision 4 of section F. I'm looking now, basically in the middle of page 5. It says to qualify
Okay,
for admission
gotcha.
to state bar, you have to complete
Gotcha.
all the other
Okay.
requirements within 12 months.
I see it now. Thanks.
And that 12 months, to be fair, that's a discussion point. That was somewhat arbitrary. I was trying to, I knew I was thinking of that same issue, Paul, and trying to figure out sort of what that limitation would be in order for them to complete the remainder of the requirements and get admitted under this sort of extraordinary way of saying you don't have to take and pass the bar at under what the current rules are for pass rate. It seemed like 12 months was sort of a good number, but I'm certainly open to other suggestions.
Well, I think it's a good and reasonable number, but I see, we're going to have another whole nother brand of headaches at the Committee of Bar Examiners when people procrastinate and, or the moral character system doesn't immediately generate the answer they're looking for them.
Well, I would think that if they're part of the provisional licensure program, I mean, I hear your point,
No,
Paul. I just hope that folks would have those applications underway and.
Well, it is on them, and it'll be they will suffer the consequences of their failure to get going on that.
Yeah.
My advice to them would be, once you enter the program, if you don't have your moral character application in, do it right away.
Well, they have to have it in order to be accepted into the program. So.
Right, and I think, and the requirement that they have a complete moral character application in is an important one, because people will submit an application. We've found, currently it will not be complete, and they will say, well, I submitted my application 6 months ago. Well, yes, but the complete application was only submitted 2 weeks ago, and we don't start acting on it until it's complete. And so in order to be in this program, you have to have submitted a complete application. And so it would be the rare case that wouldn't be resolved one way or another in 12 months.
Okay, well, so where I am is, I would go for the longest period of participation. I like the idea that the supervisor has to certify that they are competent. I don't want this just to be a quick and dirty substitute for the court having just said we're going to go retroactive. They didn't do that, so and Neil has provided a little more information, more than that's in their decision about what concerned them. So I think this program, and I'm still reluctant to vote for it, but I think I would do so only if it is a more than just a serving time, but it is a test of their competence.
Diane and then Angela.
So I'm going to weigh in differently, and I would probably go with the fourth option with the 240 to 960, not the most amount of hours, but more than your combined option. I see the need for it, but I also am a little concerned, in a COVID world, are they going to get the opportunity to get all those hours in during this period?
Hi, Lynn, can I just check something that Diane said? Diane, I thought I heard you say 960. Did you mean 360?
Well, no, I was going for the fourth option that starts with, or maybe I'm reading this wrong. It's 240 for the.
Yeah, it's the one above that, Ruben.
Okay, so
look at the page before.
Okay, I see. So up, and including all those interim steps as well, the various dates.
Well, I kind of liked the last option the best because it was the most streamlined. But I think if there are people who want a lot of hours, then the last option with the 240 and the 360 is not necessarily going to get the votes for people to get there. So I'm kind of splitting the baby.
Well, I was actually, I'm sorry, Helen, may I? I was going to suggest, because I like the idea of the streamline as well, but we're not tied to the 240 and 360 as the two levels, right? And we could certainly because there's a big discrepancy between 360 and 960, right? 600 hours is quite a bit, and we're still talking about July 2015. So staff, I don't know whether you have any thoughts on the wisdom of adjusting those hours up at the bottom end there. I'm probably okay with 240 for July 2017. Is it just I mean, administratively, I guess it's the same thing, right, Amy? Just in terms of keeping track?
Yes, it's all going to be all about the tracking process.
Yeah, and ultimately, right, the provisionally licensed lawyer will need to submit something to the bar that says, I completed my X number of hours, therefore, you know, I am eligible to be admitted. And so we're not going to be tracking them so much as us confirming that they've completed the number of hours assigned to somebody who got the 1390 or higher at the time that they did. So it shouldn't be any more of an administrative difficulty. It's a matter of the working group's thought process on what the right level of what number of hours is.
Okay, Angela, and then Greg. You're still on mute.
Okay.
There you are.
So, you know, the one area I've been focusing a little bit more on is kind of the first set of hours in relation to what the supervising lawyer is going to need to certify. And my instinct is, you know, and I'm finding this very difficult, and I like it. I like some tiering, and I think overall most of these seem very reasonable. But as a supervisor, you know, when I'm working with, you know, a brand new attorney and giving them the kind of work that would be appropriate for them to do, and then to be able to do a declaration about, in my opinion, they possess the minimum competence. At first glance to me, the 3 months with the first one, the first hours, what is it? Like, let me move my scroll up here. The 480 hours kind of felt to me like that may be the amount of time supervisors would need to be able to then feel comfortable with that certification. Because again, it's not going to be a situation where you're going to be sending somebody out to do, you know, handle a trial, or, you know, they're going to be assisting probably because they are brand new attorneys. So I'm sort of leaning toward, you know, the 9 to 12 weeks, at least in the beginning. And I just kind of feel like I'm probably more flexible at the end about maybe it doesn't have to be a full year, or can be less for people who have not been, you know, who took the bar back in 2015. But I'm just wondering if the hours are too short up in the front end, if supervisors are really going to be in a position to make that certification. That's kind of what I'm struggling with.
Good point. Greg.
Well, I don't want to get everyone off track, but I just had one quick comment about the 12-month requirement that they need to complete the other, satisfied all the other eligibility requirements for admission within 12 months of completing the supervised legal practice hours. My understanding is that the provisional licensure program, this expanded program, also expires on June 1st, 2022. And if somebody is completing their hours in that final year, say January 2022, they only really have 6 months or 5 months actually to satisfy. So we might want to change that to say within 12 months of following the completion of the hours or the expiration of the program, whichever occurs first.
So it does talk about 12 months following the completion of the required number of hours.
Right, but what I'm saying is if somebody waits and doesn't complete their hours until later in the program, they don't have 12 months left. They have fewer months left because to complete the other eligibility requirements for admission. Because the whole program is going away as of right now. It's going to sunset on June 1st, 2022.
So your proposal, Greg, is 12 months or some shorter period of time, whichever comes first?
Or for the for the group to consider that, because if we are incorporating the sunset requirement from the origin, from Rule 9.49,
Yeah.
then these provisionally licensed lawyers under this rule have to complete all these requirements, the supervised hours and all the other eligibility requirements for admission before that date. It's
Yeah.
not going to continue beyond that date.
That makes sense. Angela?
Some of these folks maybe just be doing this part-time. You know, that they may not be able to be being a provisional a licensee, full-time. And so it may be impossible for some people to be able to complete it before the end of the program.
I think it's the hours they have fully until the end of the program to complete their hours. The provision that I think Greg is referring to is the sub provision that applies to completing the other items that they need. So for example, the MPRE and moral character. So you have to have submitted your moral character application in a complete moral character application in any event in order to be part of the program, in order to, start accruing your hours. And so it seems to me that those two sort of meaty requirements would not be so difficult to meet, even if you took up until the last day of the program to complete your hours. So perhaps the proposal could be the shorter of 12 months after you complete your hours, or, just throwing out there 3 months or 6 months after the end of the program.
This is Paul. Addressing that, sounds like Greg's concern is that the expiration of the program might terminate the ability to complete those extra steps after. And so maybe when we talk about the termination of the program in the rule, we can simply say that you still have 12 months after that to do the rest of the work to get your license. So in other words, the termination of the program doesn't terminate the authority to use those hours to waive the bar. So just a drafting issue, but
Yeah, I'm just concerned that some people may be unaware of this sort of hidden time limitation.
yeah, it is one of the things we tend to do at the bar, is we're sometimes kind of obtuse in the way we write things, rules, just personal opinion. And I would imagine there will be FAQs or something for people, and we should make it clear that you have to get your hours in before the program expires. And then you have your 12 months, up to 12 months, depending on when you completed your hours, to do the rest of the work.
That's a good point. I think, Donna, we should build into the program sort of the mass email communication at certain points, right? As we're nearing the conclusion of the program, or 6 months before the conclusion, and 1 year before the conclusion, some sort of reminder goes out.
Mm-hmm. Absolutely.
Sorry, Dolores, did you have your hand up?
Am I on? I did. I was confused. So it's not so much the hours that we're concerned that they might not be able to finish in the time period. It's the other requirements, right? Because in order to participate in the program in the first place, they have to have secured a supervisor and some kind of position. So the hours of 6 weeks, if it's the minimum, that shouldn't be a problem if you have 12 months to complete it. So we're talking about the other things, like having their moral character finished, and what else?
Passing the MPRE.
That you need 12 months to do that, and you need 12 months to finish your moral character. I don't see that as a problem. Well, not 12 months, maybe even 6 months, but okay. So I see the problem. If someone enters the program in January of 2022, and it's going to sunset in June of 2022, they're not going to have enough time. Is that basically the issue?
Yeah, I just want people to understand that, if this is what the group is going to suggest to the court, that the opportunity to be admitted through this rule terminates on June 1st, 2022. And my concern with the way this was written was some may expect that they have 12 months after they finish their hours. But the later we get into this program, that will not be true as written right now, because the entire program goes away on June 1st, 2022.
But it seems like we can draft around that and
Yeah.
say, irrespective of the sunset date in 9.49, you have 12 months, right? So if the committee wishes to, we could, I mean, that's an absolutely valid point with the way it's drafted, but we could draft around that problem if that's the direction that the committee wanted to go in.
Yeah, and the only thing I'd add too, and I agree with all these points, is that, you know, you also have to keep in mind there may be folks that took the October bar exam, and they may be looking at whether or not they passed that at the 1390 score, and then they may be, if they don't, they may want to then enter this program that we're drafting right now. So what that means is that their time is running out, right? And the same may be true for folks that are thinking about taking the February 2021 exam. So.
So if I could get just sort of direction on that one question that we're talking about in terms of should we recraft the language to give 12 months irrespective of if you finished your last hour on the very last day of the program, or rather should we be clearer that what we're saying is you have 12 months or June 1st, 2022, whichever is sooner.
Diane.
I think I like the latter. You know, to be clear, you have the program's ending and this is when you got to get it done. So keep that in mind, but I'm not wedded to it.
Ruben.
So just to be clear, if you get to June of 2022, you finished your hours, but you haven't completed the rest of the requirements, you may not practice as a provisionally licensed lawyer after that June time, but there's a lag time between which you can start practicing again as a full-fledged lawyer, fully licensed, if you complete all the other requirements. Am I understanding it correctly?
No, so I think what Diane was voting for was if you complete all of your hours by June 1, 2022, but you have not yet taken and passed the MPRE, for example, then the provisional licensure program terminates by its terms. You have not met the other requirements that are necessary for admission within the time of the program's existence. Therefore, your path to licensure is taking a bar exam again and scoring a 1390 or higher.
And you may not practice as a PLL
right
after June. Okay.
It does raise this interesting question of like, what if there's just this bridge time between the termination of the program and when somebody's, you know, application through this pathway to licensure, or I guess regular licensure, is approved. You know, all of a sudden somebody could be like inadvertently engaging in the unauthorized practice of law.
Well, I mean, they should know
Sort of
better, but I am in favor of letting them complete the requirements after the end of the program. You know, they will maybe have to quit for a while if they didn't work diligently to get fully licensed by the time the program ends, but that's on them. But it does at least afford an option for those who have to work less intensively due to other commitments to eventually become licensed.
Diane.
But how long after? I mean, then I think Halen, you had, or Madam Chair, you had said maybe 3 to 6 months after. I mean, is Paul suggesting indefinitely?
No, I'd go with the 12.
Or you go a year after June 2022?
Yeah, just, it's the same requirement that's already in there, that once you finish your hours, you have a year to finish everything else.
Well, I guess maybe I'm getting confused because I mean, you have a year up to June 2022, right? And then we're just trying to figure out what happens at
Yes,
June.
so it sounds like to capture those thoughts, we would amend this by saying it's within 12 months following the completion of the required number of supervised hours, or 12 months after termination of the program, whichever comes later.
No, whichever is earlier. Actually, there wouldn't be. The only case where it would trigger would be where somebody finishes on the last day of the program. And then I would say, just as if they had finished 6 months earlier, they ought to have 12 months from that time of finishing to finish the other requisites.
You know, in my mind, when you say that a program ends on a certain date, that implies to me that everything has to be finished by that date. Not this is a date, but then you get an extra year beyond that. I think it's generous as is to go to all the way out to June of 2022 without adding another year potentially.
Well, they won't be they won't be practicing. They'll have to quit practicing until they complete the requirements for full licensure. So it's not smart for them to put themselves in that position, but maybe they don't have a choice. You know, other commitments, other reasons. It's addressing the comment we heard earlier that, you know, some people are not going to be able to work full time at this.
So Neil and then Rob.
I think Greg had his hand up too.
I know, and then he lowered it. I couldn't tell, but Neil or Greg, go ahead.
Yeah, Greg, why don't you go ahead, Greg?
Well, no, I was just going to bring up the point that we're really discussing two issues. How much longer after the program expires can they fulfill the admission requirements? And are they going to be allowed to practice past that expiration date as a PL?
Yeah.
And so there's two issues there. I think administratively, it's going to be a lot easier if the entire program terminates on a date certain. And if you don't get your application in by then and have satisfied all the criteria, your opportunity for this pathway to licensure has closed.
Yeah.
And I think what I was just bringing up was just some rule drafting issues that I saw that may be a trap for the unwary. We could change that through the rule drafting, but really try to educate these provisional licensees through FAQs about how they are supposed to manage their time and try to meet their requirements between now and June 1st, 2022. Because it may be, even though it seems like a generous amount of time, which I think it is, they're especially if they have a passing of a 1390 grade that goes back to 2015, they have a lot of work to do to get to that point. So I just want to make sure they're aware of it now and they can plan accordingly.
And to follow up on Greg's comment too, the other concern too is look at it from the consumer perspective. Say, for example, one of these provisionally licensed lawyers is representing somebody right on June 1st, up until June 1st, 2022. And all of a sudden the rest of their paperwork to become admitted into the bar isn't complete yet. What does that client then do, right? So maybe that leans in favor of saying you have the same termination deadlines as everything else on June 1st, 2022. That's for the group to actually decide. Also, the other thing I'll point out too is if we're talking about June 1st, 2022, we are talking about 18 months roughly, because if this rule comes into effect, that's 18 months, 78 weeks, right? Roughly 78 weeks. If you look at, for example, what's on the table here for the folks that are coming out of July 2015 with an exam score of 1390, we're talking about under one of these proposals, 960 hours, that's 24 weeks. So that's 24 weeks out of 78. So just throwing out those numbers so you get a perspective.
One thing that I would also mention that occurred to me as we were having this conversation, which argues in favor of what Greg and Neil were saying is the public protection angle, which is there is also a greater risk of UPL, unauthorized practice of law, if somebody, right, was a PLL, program expires, they haven't yet completed their MPRE, or they can't pass sort of a check on having, unpaid child support arrears, so they can't get admitted to the bar. There's a greater risk at that point of them continuing to provide legal services, whether, by their confusion, because that's, what they need to do to earn a living. And that might be sort of from a public protection angle, something that the working group wants to consider, as Greg had said, ending everything on June 1st, 2022. You have to meet all those requirements by that date. And if you don't, then that pathway has closed.
Go ahead, Angela.
Yeah, I think that's really persuasive, what Donna and Neil are talking about. And I think as an employer, knowing like I'm, going to do this and it's going to be seamless, I think is a really good point. And the issue I raised about people who might be doing this part-time, I think I was confused. I wasn't intending that to be that it's difficult to do those other parts of the program. I was just thinking of it in terms of how many hours on the for those who took the bar in 2015 should need to complete, given that there's a finite amount of time that they're going to have. I guess we're talking now 78 hours or 78 weeks. So I think that the point I made is really off topic, at least how I was intending it, is really to the question of how many hours to require.
So we go back to the hours issue.
Oops.
Since we only have 40 minutes left, and it seems like there's we spent a bunch of time on this one topic. See if we can come to some agreement. Rob, you had your hand up, and then Rupa.
Thank you. Just two kind of quick things. One, there are certain matters that are beyond people's control, and I believe Paul mentioned it. Things like, and they may be the rare circumstance when the moral character process is problematic for someone. That can go on for a considerable amount of time. And there are also, I'm thinking about statutes that have the kind of infamous other clause at the end, where there are things that occur that we haven't thought of, but there may be extraordinary circumstances for someone, a severe illness, which is not out of the question here in COVID time. That's why I'm in favor kind of a longer time period at the end to sort of catch anybody who, not through any fault of their own, is delayed. Either they've got to spend more time because they got to work at some other job, or there's an extraordinary circumstance like illness, or the moral character is taking longer. I'm not sure how to deal with that, but I'm just trying to anticipate somebody who says, hey, I don't fit. It's just my thought.
Yeah. Okay, Rupa.
Okay, thanks. So I wanted to go back to the hours discussion, if that's all right. And I wanted to say I was in favor of the final option, the sort of streamlined 240 hours and the 360 hours. And the reason being is my understanding is we're talking about, the new cut score is 1390, and we're talking about sort of a 5-year going back of people who got that score. And when I think about like my time as a junior attorney, the day I got sworn in and went back to my law firm the next day, they were still supervising me, right? So what I'm hearing a concern about from people who are advocating for higher hours is I feel an assumption that after they're certified, they're not going to get any supervision. But my understanding, employers correct me if I'm wrong, from my own experience and being someone who talks to employers a lot, is even after they're certified and a fully licensed attorney, most junior attorneys do get supervision, right? from other attorneys. That's sort of how we operate. I thought the concern was to require hours was a concern that someone would just go hang their shingle, especially someone who might have been out a while. And so I do think some hours is good, but I would vote for the least amount of hours and the most streamlined. So the 240 and 360. And just remember that even after they're licensed, in the typical way that junior attorneys get hired, they do still receive training, even from solos, from large firms, however it is.
I do think though, I mean, once they are licensed, there, it is entirely possible for them to go hang their own shingle. And it would sort of be incumbent on them to make sure that they are getting the appropriate mentoring from others.
Can I make a quick suggestion, Halen?
Oh, go ahead, Neil.
It seems like this issue that we were just talking about now, and thanks, Rupa, for bringing it up. You know, the number of hours required, right, to become a normally licensed lawyer, I think that question needs to be answered first. And then, you know, if we come up with a set of hours that makes us be less concerned about whether these folks can finish everything by June 1st, 2022, then that's question number 2, right? I think. I think we lost Halen. Oh, you're back.
Yeah, I think it's, I mean, I don't know that they have to be sequential though, right? I mean, you can take the MPRE while you're doing your supervised hours. Your moral character is going on. If you didn't have a positive moral character determination prior to entry into the program, you have a complete application. So the work is primarily being done in the Office of Admissions, doing the analysis while your provisional licensure program is going on. There aren't a lot of requirements on the applicant. And so certainly I think they can be done simultaneously.
And can I also remind everybody that within the rule, we also noted that if in fact you have not completed your MPRE, you could take the 4 hours of the legal ethics portion of the new attorney training. So, and that has to be done within the first 12 months. So they would have satisfied that requirement at that point too.
But that doesn't satisfy the requirement for the regular licensure. So they'd still have to do that.
Mm-hmm.
Okay.
And one more thing to keep in mind too is that because these are all prior examinees, they probably have moral character applications already in the queue. And those moral character applications, if they received a positive determination, are good for 3 years.
Yeah, we're running analysis of the incoming applications. Tara has that. I don't know if you want to report back of the applications that we've received, how many of those have a moral character application and the status that they're in as well. And you're right, Neil, many of them are coming in with the moral character application.
We only have 24 cases where the provisional licensing application has been submitted and the moral character application submitted but not yet filed. We have 298 who have a provisional licensing application who have already either a filed or positive moral character determination. So it's pretty low right now.
And filed is our terminology for it was complete.
Yes, thank you.
Right, it's being processed, but it's complete already in the door when they submitted that.
So we're coming up on just about a half hour left to go. Could I propose that we take a very brief break and come back online at 3:30? Because I know folks have been going for a little while to hopefully finish up some discussion. All right, we'll come back on at 3:30. All right, welcome back, everyone. I know that was a short break. I had one thing I wanted to mention in response to the point that Rob raised. And I don't see Donna back on, but I mean, we did in our previous discussions, and I think as reflected in the rule that's adopted, we did leave open the possibility that depending on changes in circumstances and however this COVID pandemic develops, that there is a possibility for extending the time on that pandemic. I know that none of us can predict what will happen between now and June 2022. But depending on how things go, and if we see this program developing in a way and the usage of the program developing in a way such that if we were to, adopt some rule that had a cutoff date and we needed to extend it for whatever reason, that could be something we could take up again. Right, Donna?
Yeah, so the language of the rule says that the program ends June 1, 2022, unless further extended by the Supreme Court.
So if we were to adopt in this rule, that new extension of the rule that we're discussing, or expansion of the program to allow a pathway to partnership, depending if we set the cutoff so that it sort of mirrors exactly, if for some reason things develop in a way where we really see a need to extend that for folks, we could revisit.
Yeah.
Rob, go ahead.
Yeah, that would address my concern. If something extraordinary happens, even in the individual case, somebody says, I just don't fit the mold. The other thing, just a quick thing, and it's probably not worth a lot of time, but I want to do it before we get back into the hours. And that is, someone mentioned, what about folks who are working for lawyers who are not admitted in California? I'm thinking about immigration law lawyers who practice only in the federal courts. I don't think we intended to eliminate people like that, but I also don't think they're included. Am I correct about that? As supervisor.
They should still be barred in California if they're practicing even in federal court in California.
Well, this is my ignorance is showing. Is that true for immigration?
Well, we have an expert here. We have Philip can weigh in on this.
But at least for the U.S. Department of Justice, we all work for the Attorney General. So we work under the Attorney General's authority. So we have many lawyers who are not barred in California, but the Attorney General is authorized to practice in federal court in California. I don't know if all of the federal departments work the same way. So you may have a lot of federal attorneys or federal government agencies practicing lawfully in California who are not licensed here.
Yes, that's my.
Many of AUSAs who are not licensed here.
Well, and I think we certainly didn't want to and didn't think we had the authority to speak to, what you could be, whether a provisionally licensed lawyer in California could appear in federal court. That's not within our jurisdiction to make that call. And so, we certainly weren't extending it in that fashion. We were talking about people who the assumption was these were people who would be practicing California law, and therefore they needed to be under the supervision of a California licensed attorney who could properly guide them in California law. I worry if there would be too many examples that we couldn't address if we try and expand beyond that. But that may be a failing of my creativity.
Greg, do you want to address that? And then Cindy.
Yeah, my understanding, this was intentional. We need the supervising lawyer to be within the disciplinary authority of the court. They're assuming professional responsibility for the lawyer they're supervising, and that is our regulatory hook here, really. And I think that was intentional. And even within, I think, the AG's office, you can designate for purposes of this provisional licensure program an attorney within the office who is licensed in California to supervise that attorney. And remember,
Yeah,
we put a lot of flexibility into that supervisory role too. So there just has to be one person designated as a supervising lawyer, and they can then delegate the authority to supervise to others, but they are ultimately responsible for the work of that PL.
Yeah, I don't imagine, and Philip, you can correct me if I'm wrong, that there are many federal agencies in California where it's 100% lawyers barred in other jurisdictions.
I can't imagine.
Yeah.
We have mostly California barred lawyers, only a handful not barred here. So it would be relatively easy in my office. The other issue is I haven't checked whether the Department of Justice would allow us to hire a California provisionally licensed lawyer if they would be considered licensed under federal regulations. So.
Cindy, did you have your hand up?
No, I think I was just going to point out what Greg pointed out, I think.
Well, correct me if I'm wrong, but doesn't the bar have authority over, and I don't know if we have the time for me to open up the California rules and look at that one towards the end, that it sounds like it's pretty broad authority under the rules adopted in November 2018, but I think it was also the rule before that the bar, if you commit some sort of misconduct, no matter where you're licensed, if the misconduct happens here in California, we can reach you. Am I mistaken about that?
The rules reach those lawyers practicing in California under our multi-jurisdictional practice rules. So we changed the rules. All the rules used to be refer to members of the bar. We've eradicated that term from our vernacular in all our rules now. So we refer to licensees, but the rules of professional conduct apply to lawyers practicing in the state, and that may not include licensees of California, but they are lawyers that are practicing under the rules of court. But we also remember we expanded this rule to allow provisional license lawyers to practice outside of the state as well. And so I really don't foresee the court wanting to revisit whether or not these supervising lawyers can be barred in other states, but not in California. It makes it very difficult to regulate the program at that point.
Yes, I'm thinking of a professor at our school who teaches immigration law. She's practiced for 30 years, and she's quite famous, but she's not barred in California, and her practice is here in California.
Well, a lot of lawyers will pro hoc in and will just do it every time, sort of as a matter of course. They'll just pro hoc VJ in. I mean, I had a professor like that, and he and I ended up taking the bar exam together. And I said, "Professor, what are you doing here?" He said, "Oh, I just got sick of always submitting a pro hoc VJ. I just decided to take the exam." So I want to be mindful of time, and on the hours requirement, it seems like there's a real diversity of views. And also I wanted to let you guys know that Carol Langford, who couldn't make it, wanted me to share her views with this group, which is that she thinks that we should pick the maximum hours. And that's where her bias lies. But I wanted to get Neil and Greg your guidance as to whether it would be acceptable to present to the Supreme Court maybe two different options. If this group could kind of come to some sense of, a structure. Do folks like the much more graduated sort of 2-week incremental increase, or different increases for every single different year? Are folks comfortable with a more compressed approach? And then perhaps we could come at it from kind of two different options, because I'm not sure we can reach complete consensus or agreement in the time we have allotted. Would that be something that's acceptable?
So if you're saying, in other words, give the Supreme Court an A and B choice pathway, one that could be a different number of hours for each particular exam we go back in the past, or like the last option, which is a more sort of consolidated approach, right? Is that what you're saying?
Well, or I was actually hoping we could come to some agreement as to approach,
Right.
decide between the much more graduated structure versus a more compressed structure,
Right.
and decide, but then present using that same structure, two different options, one that's a little longer, one that's a little shorter.
Yeah, I'm sure the court would be open to multiple options, and that would certainly help. So.
Okay. Ruben?
So, hey, Lynn, maybe the first question that we should try and get consensus on, sorry, my dog is here, is the streamlined approach with an hours to be determined versus the
Yep.
graduated approach.
Yep.
And with that in mind, I'd make a motion to go with a streamlined approach. And then maybe the next question is what the hours are.
And I would second that motion.
Thank you. Any discussion of that approach? Objections? And are folks comfortable with the cutoff that is used in that approach? So we're looking at the top of page 5 of the document. The two options are sort of, anyone going back to July 2017 and then 2015 to 2017. Folks comfortable with that cutoff? Philip?
Just there's slight discussion. I think Rupa brought this up as an advocate for the streamlined approach. I would almost go with just one amount of hours. I think Angela said earlier that there's a period of time in which a supervisor needs to assess a supervisee in order to determine whether they have what it takes to be licensed as a lawyer. And so I'm much in favor of the streamlined approach and would almost, argue for a single hour amount, whether it's 360 or so, something that is achievable so that a supervisor is willing to take on the job that won't stretch out for too long a period of time before successful completion, but long enough they can make that assessment. So I'm anyway, just for discussion purposes.
Any reactions to that, Ruben?
Yeah, just my sense is that using the two-tiered approach, not two-tiered, but longer and a shorter, is mindful of what I hear to be the court's desire to account for a passage of time, and I understand it to be, at least from what Neil and Greg have said, to be sort of important to the court. So I guess the question might be, how important to the court is it? My sense is that it is important, and as a trustee, it's important to me too. Just mindful of, we're in the middle of a pandemic, and everybody's not everybody, lots of folks have their attention in different places, and taking the bar in 2015 is way different than having taken in 2019 or 2017.
And Ruben, it's not only maybe what the court thinks, I think it's just a matter of fairness, right? If folks studied and prepared hard for the February 2020 exam, it's still something that is fairly recent. They still probably have all those basic precepts in mind, and it just seems fair to have them not have so many hours required as somebody else coming in from 5 years ago with a 1390. I think it's just a matter of fairness.
Okay. Other discussion? I'd like to wait for a vote until after we have more to vote on, so we don't have to take time with the roll call. Okay, if we take this streamlined approach of having two tiers, I was persuaded by Angela's, I think it was Angela's statement about feeling more comfortable with some more hours on the lower end. For me, my frame of reference is, how long we have our summer associates in for our summer associate program, which is typically around 10 weeks. And I do think something around 10 weeks is needed to really see the type of, enough work product. So much time is taken, things take longer when you're brand new. And so I think to see a sufficient amount of work product, I would be more comfortable with a longer period of time.
So are you suggesting 400 hours for the 2017?
No, I mean, I would go with 360. That's, the Utah requirement is 360. It's a nine 40-hour weeks. I don't think necessarily that summer associates are working 40-hour weeks, but so I'm comfortable with the 360 hours for that first tier. And I think that's what Angela had suggested too.
Yeah, I would be comfortable with that. And, and thinking about the 2 tiers too, it may be if somebody has really been out of law school much longer and has been doing something else and not in the legal field, you might be giving them different types of things in the beginning. So having more hours for the group that have been taking the bar a lot longer ago, maybe it also makes sense in terms of needing time to kind of assess the work product of those folks. So that might also support having a 2-tier program. But yeah, 9 weeks, I think that, full time, I would be comfortable with that.
And then
Oh, sorry, go ahead, Diane.
would you do the same spread? So about 480 for the second tier?
I think that sounds sensible to me. Rupa?
Well, okay. So I'll just read, I think I'm probably the most liberal one today on this, that I'm still not understanding what the concerns are for wanting such high numbers, because had 1390 been the cut score, back then, nobody else who passed the bar would have had this kind of requirement of hours, right? So it's not something we impose as a restriction to become a lawyer. Certainly in law school, we hope that they get that experience. We hope that they're summer associates and all of that, but it's not an actual requirement. So I guess I'm struggling with why we are requiring that if they got what is now a passing score, but they got it a little bit ago, we're requiring such a number of hours, which we don't require on others.
Well, so one thing that does occur to me is, that effectively is making the cut score retroactive, which I don't think is necessarily within our purview. I don't think that that's within our charge. So I think that may be part of what's driving this discussion. But I also just think that to me, it's persuasive that there is this passage of time issue from when folks have taken it. But, I understand that folks can disagree on that. Jennifer, you have your hand raised.
Oh, I was just going to make that point too, that I think the court has kind of already given us the direction on that and deciding not to make it retroactive. So in my head, I'm just trying to think kind of roughly like if you were going to sit down and take the bar now and try to pass at this lower rate and you haven't been really studying the law for the last 5 years, what would your bar prep look like? How many weeks would you need to put in? How many hours in order to get up to speed? And the more recent that you were in school, maybe the less hours you would need to put in, right, to get up to speed. We're just trying to come up with like a work equivalent of bar prep, essentially, in order. Otherwise, we're just doing the retroactive application of the lower score, which the Supreme Court has already decided they don't want to do. So, there is some rationale, I think, for a little bit more bar prep in the form of work to get up to speed for people who haven't taken a look at this. And, just trying to think through how many additional weeks that would kind of work out to. I mean, it does feel as a decider, it feels a little arbitrary trying to come up with these numbers. But what is proposed with the 360 to start, and then, however many hours above that, if 2 to 4 more weeks for the people who have been out a while longer to kind of get up to speed makes sense to me.
Just really quickly, Jennifer, it is about 360 hours. Some people say 300 to 500 hours to study for a bar exam, but it's 360 is sort of around that in the neighborhood.
But I think Jennifer makes a really good point, because I think that, right, it's typically they say like 10 weeks, but that is assuming that you are, sort of just coming out of law school or are up on the precepts that you would need to know for that. So it's a really interesting comparison. And it really is sort of a question. In my simplistic mind, it's easier to say, if we say that 360 hours, that nine weeks, how many more weeks, as Jennifer phrased it, like how many more weeks is necessary to get up to speed? And that's ultimately the question. Hyland, I think you put on the table 480, you and Diane, which is an additional 2 weeks, the equivalent of 2 40-hour weeks beyond the for the people who pass.
I think it's 3. right? 3 40-hour weeks, because it's 120 hours.
Yeah, you're right. So yeah, an additional 3 weeks for that. So I think that's sort of the guide. The question then, is that the right number? Should it be 2 weeks? Should it be 4 weeks? It should be 3 weeks.
So Paul has his hand up, and then Rupa, I think, wanted to respond to.
Yeah, I just don't see a couple of weeks more for those who have been out away from it longer is enough. I'd come close to half again, or maybe even doubling. I could be uncomfortably comfortable enough to vote for 400 and 600, but below that, I'll be voting no, for your information.
So I just wanted to reiterate, I mean, I read the 100 pages of comments that people submitted, and it looked to me like a lot of people were explaining how, you know, they passed the, they got a 1390 score and they are working, or some of them are working in a related field and things like that. So, so I guess I'm not concerned that so many of the people trying to go for this are going to have been away from the legal world. I think the people who are going to be interested in taking advantage of this licensure option are people who have stayed close to the legal field and already might be working at law firms. I saw a lot of lawyer letters saying they have someone who got a 1390 and they just can't wait. They think this person's going to be a phenomenal lawyer and all of that. So I read all of that. So I'm just not so concerned with upping the numbers, because I feel like these people, out of a concern that they've been away from it. And I agree with what everyone's saying about not just a retroactive 1390, which is why I was thinking the 240 and the 360. I mean, so I guess with Paul, like yeah, I mean, I don't know. We'll see how the 600 and 400 go, but that would be the very high end for me, because I just don't think that it's necessary to feel that they are not staying close to this, and that someone who's completely been out. I did read someone was a nurse, but they want to use their legal field with their nursing degree, and they are not concerned about getting the hours as long as it's reasonable to do that kind of work.
Well, to respond, at some point, they don't spend enough time with the supervisor for the supervisor to provide a meaningful assessment. And that's where I was starting from, was actually my preference would have been the full 3 months, which I think was what somebody originally mentioned. And then adding significantly to that for those who have, well, who are further back. But if we want those assessments to be serious, we need to give them the time and the exposure to the individuals to be able to do that.
Angela?
So if we did the 400 and 600, I'm making sure my math is right, it would be basically 10 weeks full-time versus then 15 weeks, which I don't know. And thinking of, most situations, that's, to me, doesn't seem like a lot, unreasonable.
So one issue that also, I hate to add to the issues we have to consider, is for those of you who have looked at subdivision G in the proposed rule on page 5, there's also a proposal that the supervising lawyer provide an evaluation, basically saying, I verify that I've supervised this number of hours. Here's the type of legal work this person has done. And I think my sense is that this sort of certification is meant to just, make sure that folks actually do this. But then there's this certification that we think that the supervising lawyer has to say, I think that they possess the minimum competence to practice law. And I just think that may be hard for someone to say unless there has been a minimum number of hours. Just again, thinking about, a 9-week summer associate program or 10-week summer associate program, could you say at the end of that, this person's minimally competent to practice law? The other, I noticed, Donna, in subdivision 2 that it says minimally competent to practice law without supervision, which raises the issue that Rupa talked about, which is, even lawyers that are licensed under the normal licensing program, when they first come in the door, there is so much they don't know how to do. And so, if they were coming into any sort of entity, whether a nonprofit or a public agency or whatever, you'd be supervising them.
Mm-hmm. Yeah, you'd be supervising them, but the state bar is not regulating that you do that. They are already licensed. Yeah. You're just doing that as part of the profession to make sure they're competent working with you, right?
Well, you're doing it also because you have a professional obligation under the rules of professional responsibility to make sure that, because it becomes on you as the firm manager or the manager of the entity.
Correct, but they're already licensed.
Yeah, and the point was to get at sort of if we were to use a normal bar exam, right? You pass the bar exam, you're admitted, you were deemed minimally competent to practice. You could hang out a shingle, you could work at a firm where you'd be supervised, and that is your call. And so, we are effectively saying that you are, with bar passage, minimally competent to practice law without regular supervision, since you do have the ability to hang out a shingle.
So are we finishing at 4, Halen? Is that the idea?
That was the time that was allotted. I fear that we may lose our quorum at 4.
So, is there the ability you were going to provide 2 different ranges, right? We could vote on the range of 360 and 480 as one, and 400 and 600 as another, and see where that ends up in terms of what we submit to the bar. To the court. I'm sorry. Just a thought.
I think that's a good idea. And your last point about the supervising lawyer having to have enough interaction with the PLLs to certify is persuasive to me. And then just the point that Rupa was making about, plenty of the folks who gave us comments are already working in some capacity. I actually think that's going to just make it easier for them to get the hours, right? If they're already working in some legal related sphere, once they get into the program, they're going to have a ready-made hours machine, for lack of a better word. And so hopefully this will not be a big burden to those folks. And so with Diane, if that was a motion, I'll second it, that we use those 2 ranges.
That's my motion.
I'll second it.
All right. Any discussion? Folks ready for a vote?
Well, how do I indicate that I am only in favor of the 400, 600 and not the other?
We could divide the question, I suppose, 2 different motions, and then a third motion that whichever one, we'd have to revisit it, I guess, if one of them doesn't win, right, Halen?
Well, or we could simply decide I suppose the motion could be to submit those 2 to the Supreme Court as options for consideration within the rest of this proposed rule.
What I think I hear Paul saying, though, is that he's not in favor of sending something to the court that has the lower number,
right,
or the higher. I'm sorry, the lower number. And my recommendation would be just to vote no on that motion, Paul, and then see if it carries the day.
Yeah, but I thought it was going to be combined, so I would just have to vote no on even the part that I approved.
Well, it was combined, but I'm saying we could divide it. We could see how
let's do that.
Each does. So the first one would be 360 and 480 would be my motion. If you want to, Ruben, want to second that?
Okay, I'll second that.
And I have a question.
Yes.
Is the way we're doing it, can we vote on both if we're comfortable with having the court see both?
Yes. Yes, because at the end, I think the motion would be to send both of those to there'd be like 3 motions, right? Maybe I'm overcomplicating this, but the 360 to 480, the 400 to 600, and then a motion to send both if they both get a majority. That make sense?
I think so.
Okay.
Or even we could send both, even if we does. I think somebody could vote no on one of them and still say it's okay to send both.
Okay, yeah, okay.
Okay. All right, so the motion that is on the table is 240, 360?
No, 360, 480.
Oh, sorry, I'm like looking at the wrong dot, 360, 480. Okay, Ezra, did I lose you? I don't see
I'm
Ezra.
here.
Oh, there you are.
Yeah, hi.
Everybody shuffled around for me. Would you mind calling the vote?
Yes. Hai-Lin Chen. Ruben Duran.
Yes.
Rob Barrett.
Yes.
Rupa Bandari.
Yes.
Diane Boyer-Vine.
Yes.
Julie Crisp.
Yes.
Dolores Heisinger.
Yes.
Jennifer Bacon-Henning.
Yes.
Paul Kramer.
No.
Laraz Moody Villarose.
Yes.
Cindy Panuco.
Yes.
Vern Pearson. Oh, sorry. Angela Sierra.
Yes.
Philip Talbert.
Yes.
And that's all.
Okay, great.
Want me to make the second motion, which is the 400,
Sure.
400 and 600?
I'll second that motion.
Great. Ezra, could you call a vote, please?
Hai-Lin Chen.
Yes.
Ruben Duran.
Yes.
Rob Barrett.
Yes.
Rupa Bandari.
No.
Diane Boyer-Vine.
Yes.
Julie Crisp.
Yes.
Dolores Heisinger.
Yes.
Jennifer Bacon-Henning.
Yes.
Paul Kramer.
Yes.
Laraz Moody Villarose.
No.
Cindy Panuco.
No.
Angela Sierra.
Yes.
Philip Talbert.
Yes.
All right. And then I think the last one is just to have both options sent to the Supreme Court as part of our proposed rule.
Can I clarify that it goes to the board, the full board of trustees, and then the board would
yes.
take the action and send to the court?
Yes. With that clarification. Thank you, Donna.
Is that your motion then, Halen?
Yeah, that'll be my motion.
Yeah, I second it.
All right, thanks. And Ezra, would you mind calling a vote?
Hai-Lin Chen.
Yes.
Ruben Duran.
Yes.
Rob Barrett.
Yes.
Rupa Bandari.
Yes.
Diane Boyer-Vine.
Yes.
Julie Crisp.
Yes.
Dolores Heisinger.
Yes.
Jennifer Bacon-Henning.
Yes.
Paul Kramer.
Yes.
Laraz Moody Villarose.
Yes.
Cindy Panuco.
Yes.
Angela Sierra.
Yes.
Philip Talbert.
Yes.
Thank you.
So, okay, Donna, the other items that we needed, I think it sounds like we needed a decision on this cutoff, the time to completion of requirements.
Yes. Yeah, there are a couple of things that we need to just get final on. So that is one of them.
So the rule as drafted, which is in the middle of page 5, it's subdivision 4 of subdivision F, I guess, is to qualify for admission to the state bar, the PLL shall, within 12 months following completion of the required number of supervised hours, satisfy all the eligibility requirements. We've heard a number of different options discussed. One would be to extend the time past the end date of the program in some way. but it then raises the specter of there being this sort of stub end of unauthorized practice of law, or where, you know, the person would have to stop practicing law, and that could leave clients in a lurch. It sounds like some of the concerns that have been raised could be alleviated through clear communication with folks who are using this pathway, that sort of, you know, here's the cutoff dates, and in order to satisfy them, you really, like, here are the times to take the MPR or the MPRE, here's the times to, you know, you need to make sure your application, your moral character application is, you know, you're following up and being responsive.
I think Greg has his hand up, yeah.
Yeah.
Two things. I don't want to overcomplicate this, but I think this might be actually a solution, because the more I think about this program, the objective of the program is very different than the provisional licensure program we already passed. That was to provide 2020 grads multiple opportunities to take and pass the bar exam. This is actually, the purpose is to get these people who scored 1390 at some point in that 5-year period on track and moving towards full licensure. We might want to consider a deadline by which they apply to participate in this program. So the reason being, right now there's no deadline. So somebody could theoretically, somebody who got a 1390 in 2015 could apply in December 2021 to get on the path, and that they're going to have a really difficult time doing that. If we set a deadline that you need to start, then we can start monitoring people who haven't gotten a moral character determination yet, haven't completed their MPRE, and we'll have a finite group of people that we're trying to shepherd through this program as best as the state bar can. The other thing, so that's one suggestion. The other thing that we should think about is what the individuals who complete their supervised hours, complete all the eligibility requirements for admission, submit their application for admission to the state bar prior to June 1st, 2022, but the state bar hasn't acted on it yet. Because there may be some that that haven't received a determination yet from the state bar, or who get it in only a couple of weeks before that deadline. What do we do with those people? Is their application remain alive even though the program terminates on that date?
And by the way, just to add on to Greg's comments, you know, if, just to throw this idea out there, maybe we could set the deadline to apply into this program, to enter this program, something like June 2021. The reason why I'm using that date is because if folks have chosen to take in the October bar exam, they'll find out their results by then. And also, if folks have signed up to take the February 2021 bar exam, they'll know their results by June 1st, 2021.
Yeah, I was thinking maybe June of 2021 was a good date for a deadline for the application.
Mm-hmm. I agree.
Is there a way with the people who might be, you know, for reasons beyond their control, they don't have those other pieces done by June of 2022, that they could get a special dispensation or, you know, some kind of extension on an individual basis without that they go back to the bar for that?
Yeah, they'd probably come back to the bar examiners, and I'm not looking forward to those.
It definitely becomes very subjective on who has good cause and why. I think having a hard and fast, you have to have sort of taken into account one of the things Greg just said. You have to have submitted everything. Everything is complete, and your application or whatever you need to submit for admission, I should know that. That, you know, you've completed everything and submitted your supervisor's evaluation and your statement that you've completed your hours by June 1, 2022. That way, if the state bar is still acting on it, that's through no fault of your own.
Yeah, that's what I meant. I didn't mean it. I thought everything had to be submitted. It's just, it's out of their control at that point. They've done all they could do.
Yeah.
So in F4, then we could change it. Maybe we could just say that the deadline is the end of the program date in 2022. That'll give some people more than 12 months, some less, and that they have to submit. Then they don't have to, quote, satisfy all the requirements. They have to submit proof of their satisfaction of all the requirements by that time.
And so to get at the sort of June 2021 entry date, how would that requirement be?
So we could
fulfilled? They would have to have entered the provisional licensure program by then. Is that what
probably
we're thinking of?
Submitted a complete application, the same way we talk about the moral character, that they submit a complete application by June 1, 2021.
For the provisional licensure program.
Right.
And you have to have fulfilled that in order to have this pathway to regular licensure.
And then you could probably add something to F1 that says, in order to qualify for this, they have to have entered the program prior to June 1, 2021 or something like that.
Mm-hmm.
Or June 30th. Something like that.
Yeah, I mean, that might be
July
better.
1st. Yeah.
Except entered is a little bit vague. Enters a little bit vague. Does that mean they've actually applied and started working?
Submit a full application. Greg, go ahead.
I was just going to say, we should probably not get bogged down in the actual rule draft.
Yeah.
And maybe move on with deciding whether or not the group wants to suggest that there be a deadline for applying to participate in this program. And then, because I have some other ideas about things that I would love to change in the drafting of the rule. So I think we can take that concept, if it's approved by this group, and graft it into the rule, and then come back with an actual written rule.
And I'm not going to take Greg's dissatisfaction with the rule as written personally.
That means we get to meet again?
Well, we would have to meet again to consider any public comment. We have to send this out for public comment. What I can do is, as we did the last time, I will take all the comments that we received and all the motions from today. I will work with Greg and Neil and finalize the language of the rule to be consistent with everything that we had talked about. I will send it out to the group, and you can send me back corrections. So it's not sort of in the nature of new issues. We can't sort of adopt new policy via email, but making sure it's reflecting what we've talked about.
Okay.
Okay.
So if we can maybe take a motion on that concept of deadline for application of the program, for submitting a complete application for entry into the program of June 1, 2021, and then the deadline at the back end to submit proof of satisfaction, or whatever the appropriate wording is, of the requirements by June 1, 2022. Again, understanding that the State Bar may be acting on that after that date.
So moved.
I'll second.
Second.
Great, thanks, Rob. Ezra, could you call the vote, please?
Yes, and I just wanted to confirm that it was seconded by Rob Barrett.
Rob and Paul, whoever, doesn't matter.
Okay. Highland Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp, Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Laraz Moody Villarose,
Yes.
Cindy Panuco,
Yes.
Angela Sierra,
Yes.
Philip Talbert.
Yes.
Thank you.
Great. Thanks, everyone. Looks like we're starting to lose our quorum soon. But I wanted to thank everyone for this work, and I know it's incredibly time consuming, and know that all of you who took the time to read all the public comments, it's so appreciated. I always keep thinking it's going to be our last meeting, but I get to see all of you again. So, oh, Donna, go ahead.
Yeah, so I think we need to just take a vote on the evaluation and then the termination provision.
So, okay. I don't know if we're going to have a quorum, though. I didn't hear a ton of objection to the termination, which I think is fairly non-controversial, but but could we put it over to, oh, I guess you have to put it out for public comment.
Yeah.
I mean, this was, okay.
I thought it was fine as written. And so unless there's a need for discussion, I'll move it as presented.
I have a quick question. I think, is that where it's written about it, if there's a client complaint?
Yep.
And it
Yes.
was more about like, is that like a confirmed complaint or, you know, I had questions about that and I know we're at the end of the meeting, so.
So my thought in putting it in there, right, because normally a complaint in and of itself is not
Right.
an issue. If under the under the current provisional licensure rule, you know, if you've been disciplined, that's an issue.
Yeah.
My thinking on putting it in was, you've been a provisionally licensed lawyer for 9 weeks, you know, potentially, right? It's a short period of time, and it seemed like that would be problematic if there was a complaint against you within that period.
Maybe Evanista, yeah.
Donna, I'm not seeing that complaint language in my, it's in G.
It's an E. So we're looking at page 2.
Okay.
It's an E.
Oh.
Termination of provisional licensure.
Thank you. Thank you. Okay.
This is Cindy. I'd have a little bit of a concern about due process, because what if the complaint is completely unfounded and an opportunity to address it? I don't know if maybe there could be two separate terms. Like I agree with the fact that if there's no supervisor, somebody is unwilling to continue supervision, that could terminate the license at that point because it's part of the program. But maybe an E1 or E2, like I don't know if I'm just a little concerned about due process issues and the ability to challenge, just have an automatic, because you know there could be some unfounded complaint that some client just makes. You know, I've seen that happen, and an inability to challenge it and to just automatically disqualify someone raises some due process concerns for me, at least.
Yeah, I agree with
That's
that.
fair.
You know, I think one of the ways to handle that is just to refer back to how you can be removed from the provisional license program in the rule that's already been approved. So you could just simply cross-reference the termination conditions in that rule. And that includes whether you violated a rule of professional conduct, and that would require a full litigation before the state bar court, right? So.
Which would still be going on by potentially, that's a concern too, right?
Maybe.
It may still be, there may be a complaint that's under investigation. And I just don't know what to do about that.
Does that mean that if a complaint were under investigation, it's so weird, right? Because typically when somebody's seeking admission to the state bar, there's not a pending like state bar discipline proceeding against them. So do we need to put something in to say like, your application is not going to be approved if there's a pending, or it's going to be held until the outcome of that pending state bar proceeding is determined?
So maybe like a suspension pending investigation. Donna, is there what about using as a demarcation the intake process itself, right? So if a complaint makes it through intake and an investigation is open, then it would trigger the termination or a suspension?
A lot of complaints still get dismissed with absolutely no disciplinary action. So I mean, I certainly understand and would be comfortable with what everyone's saying, that that we should leave it to the termination provisions that apply to the provisional licensure program that's already been adopted. I do think there is this a decent notion of holding that any admission to the bar would need to be held in abeyance until the resolution of that complaint, and if there's no discipline, then they get admitted to the bar.
Would that prevent them from making the 12-month rule though? Quite often.
I think they would. Still need to show all their requirements before then, right, Donna?
Well, yeah, and so we've basically eliminated the 12-month rule. We've just said they have to submit everything by June 1. I think this would be a circumstance, June 1, 2022, this would be a circumstance where we would say they could still get admitted after that date. This is the one thing that holds that off. Everything else needs to be submitted. If there is a investigation going on, then we have to wait until completion of that to determine if they've been disciplined. Because if they were disciplined based on 9 weeks of practice, it seems like that might be a
Red flag.
red flag.
Yeah, so I think we need to explicitly state that. This is a case where we don't want to have to try to fight with somebody over an interpretation of all the rules read together.
Yeah. Yeah,
And
so
you-
we can be explicit about that.
Probably need to put it in both places, Donna, both the termination and the 12-week extent, the other one.
Yeah,
Yeah,
we will figure out sort of, how to piece all that together.
Yeah, the 4. So do you need a motion, Halen, on that?
Yeah,
Sounds like we do.
withdraw my original motion. Sorry.
Okay, thanks, Ruben. It sounds like we do need a motion.
So the motion is to revise the subdivision E to remove the client complaint, but to cross-reference back to the termination provisions and the existing provisional licensing program, with the exception that they couldn't be admitted if there was a pending complaint until that pending complaint is resolved favorably to them. Is that right? If you understood that, I move that.
second.
Paul, but we're leaving in E the last part, which is if the supervisor informs the state bar of the unwillingness to continue supervising.
Yeah, I was.
I'm sorry. I actually don't think it's necessary because that's under the existing rule, really. You're required to have supervision, and if you don't have supervision, you're no longer eligible to participate. So I think just cross-referencing the other termination, original rule, take care of that.
That's a valid point,
Well,
Greg.
If you are concerned, though, that they might find another supervisor and then qualify via that route, and what the original supervisor discovered should be a red flag that eliminates the benefit for them, then maybe we do need to say it.
Well, doesn't this just say informs the state bar of their unwillingness to continue supervision?
But it says because of their conduct. So in other words, the supervisor is not saying, I just can't, I don't have the time anymore. It's saying this person is dangerous in some way.
Okay. I'm looking at E. I don't see that in E. That's.
I thought it was in there.
Yeah, it says due to the conduct of the provisionally licensed lawyer right at the end, Greg.
Yeah, so that's for the evaluation. Yeah, I had questions about that as well. But I'm just talking about E right now in terms of termination of the provisional licensure. I don't think we need the second part of that in terms if the supervisor is unwilling to continue.
But that has the same language, due to the conduct of the provisionally licensed lawyer.
Oh, I'm sorry. You're right. Okay. I didn't see that. Thank you.
I mean, I don't feel strongly about it, but if we're treating that as a, sort of like a terminating event, that a supervising lawyer called you out for your behavior, that would not be covered unless it stays in there.
Is it really necessary? Because already you need the supervisor to sign off on competency, right? And the other provision at the end of the rule in G, right?
True.
Yeah, maybe
I'm
not.
also concerned about the language conduct of. I don't. That doesn't necessarily mean misconduct.
It's vague.
All right.
Yeah.
My motion will include eliminating that provision.
Second agrees.
Thanks, Paul. Any other discussion? And I do turn into a pumpkin in 5 minutes, so I hope we can get through this. Ezra, could we call a vote, please?
Yes. Highland Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp, Dolores Heisinger,
Yes.
Jennifer Bacon-Henning, Paul Kramer,
Yes.
Cindy Panuco,
Yes.
Angela Sierra,
Yes.
Philip Talbert.
Yes.
Thank you.
Great, thank you. So the last item is the one that's on the very last page, which is the evaluation clause, which requires that the supervising lawyer provide an evaluation that includes a verification of the number of hours of supervision, a description of the legal work performed, whether the provisionally licensed lawyer possesses minimum competence to practice law, and other criteria. I would just note, Donna, and this is just a drafting issue, is that we, in that part that I just read, don't say minimally competent to practice law without supervision, but then we say that in subdivision 2, so we should just make sure the language tracks. Comments, discussion?
Without supervision is redundant, I think.
Yeah, do we need it? Angela's shaking her head. Donna's shaking her head.
Well, does this inform the supervisor though, more clearly what our standard is?
Well, we do say other criteria established by the state bar. So we may, I mean, there may be supervising lawyers who say like, it would help if I had some guidance on this.
Yeah, but I really hate for us to, rely on, statements in other places to explain our rules. And whenever we can be clear, I'd rather be clear in the rules themselves.
No, I'll withdraw my redundancy objection. Paul, you convinced me. Let's tell them like exactly what we mean. I think that's
I'm actually more nervous about this other criteria clause because that seems like an open door to the regulators that many complain about. But I think it is in our culture, so I'm only going to observe that.
I seem to be the motion maker today, and I know Highland needs to go. So are we going to approve it as written? Is that what you're looking for, Highland?
I don't know. Well, I am worried. Do we have 11? It looks like we have 11 members. Is that right, Ezra? I'm not sure we still have a quorum.
If we have 11, we're fine.
Yes, we just meet.
Okay.
Okay, well, I'll move. I'll take the burden from you. I'll move that we approve G, but we add without supervision to G1C.
I'll second.
You, Paul and Rob. Ezra, could you call a vote, please?
Highland Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari, Diane Boyer-Vine,
Yes.
Julie Crisp, Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Cindy Panuco,
Yes.
Angela Sierra,
Yes.
and Philip Talbert.
Yes.
Thank you.
Great. Well, thank you, everyone. And thanks for hanging in longer than the meeting time was scheduled for. This is such important work. And again, it's always such a pleasure to work with all of you. Ezra, go ahead.
I'm sorry. Should we approve the minutes from the October 14th meeting?
Oh my goodness. Were those I don't know that I had a chance to actually look at them. So someone else will have to see if they pointed out.
I read them. I move it.
Being that we're gonna have to have one more meeting to go over the public comment, we could do it then.
Yeah, let's do it then. Okay, let's do it then. I think Ezra will be in touch with all of us to figure out another meeting date.
I'll send
And
a doodle
until
poll.
then, okay, thanks, Ezra. So look out for the doodle poll from Ezra. And until then, everyone have a safe holiday week. And we'll see you again.
Thanks.
Thank you, everyone.
Bye.
Bye. Happy Thanksgiving.
Thanks, Dolores.